next case we will hear is People versus Gafken, also a 15-minute mini oral argument on the application. Mr. Turner, that means you can try and reserve time. You've seen how that goes, and you may proceed.
Thank you, Your Honor. I'm going to try to reserve 3 minutes.
Okay.
Madam Chief Justice, and may it please the Court, this case implicates 2 foundational parts of criminal law in the state of Michigan: free will and mens rea. Ms. Gafken maintains that a violent felon stuck a gun to her back when the police went to pull her over for speeding and told her he'd kill her unless she sped away. So Ms. Gafken obliged, but she was doing so to avoid death, not because her free will urged her to. And with the panic caused by this chaotic situation, she never comprehended the risk her 30-second police chase caused to others. This evidence should have been admissible in her second-degree depraved heart murder trial for several reasons. It should have been admissible for her to raise a duress defense, which the lower courts wrongfully concluded was unavailable for depraved heart murder. And it should have been admissible for her to prove that she lacked the mens rea for depraved heart murder in the first instance. The lower courts cast aside the common law's subjective awareness of risk standard for depraved heart murder and instead substituted an objective, stringent act-only inquiry that took away any consideration of Ms. Gafken's state of mind or any other factors of what was going on in the vehicle. These erroneous rulings of law deprived Ms. Gafken of the right to present what was the central element of her defense at trial, which is that she lacked the mens rea and she was not acting with free will. We ask the court to grant the application reverse. I welcome this court's questions at any time. I'll begin with the duress argument here because both arguments proceed similarly to the extent that they both operate against the common law rule. And for duress at common law, it was a defense to all crimes except intentional murder. It was the common law treatises dating back to the 17th century with Lord Hale's treatise drew the line based on the defendants whether they were facing a one-for-one choice between kill or be killed. If they used the example of being violently assaulted and had no other way to avoid death but killing a person then present. And when that situation was not present, the otherwise broad availability of the duress defense was available to the defendant. Michigan has always operated against this common law rule. It's never signified that it's expanding this rule in any way. And just 2 years ago, this court in Reichert took the same approach when faced with Court of Appeals precedent that had gone beyond what the common law had determined. And in Reichert, felony murder case, the defendant was faced with the choice of committing a lesser felony or what they reasonably believed was likely death. And this court held that that distinction, without that kill or be killed scenario, meant that the common law's duress defense exclusion for intentional murder was not present and the defendant could raise the duress offense. And that same reasoning that this court applied in Reichert applies equally here. Ms. Gafken never intended to kill another person. In the moment when the gun went to her back and when she was told to speed away, she was never faced the decision of kill this person or you will die. She was told speed away from the police or you will die. And so she obliged. But that same rationale that drove the result in Reichert then applies equally here. And importantly, the fact that the death resulted in both cases does not change that result. But the lower court here stuck to the common law principle, or the prior Court of Appeals precedent, which cut against the common law principle and denied her the duress defense. And the one other point to make on duress is that there's no other rationale beyond this common law exclusion that would support excluding the duress defense for any crimes. The duress defense is an excuse from criminal liability, not a justification. So to the extent that Ms. Gafken or any defendant who ends up killing another person is acting under duress, the prosecution is not without recourse. They can always proceed against the person who caused the compulsion. In this case, it's the person who put the gun to her back. That person acts with free will. They act inconsistent with societal values, and they have that same mens rea in that situation that the person who is compelled has. So that duress excuse would appear to apply to all forms of all crimes, and the common law's exclusion for intentional murder was not based on the fact that this excuse rationale falls apart, but it was based on the fact that this kind of biblical moral judgment that if you're faced with this one-for-one choice of kill this person or you're going to die, that as a matter of biblical precedent, you should stand up and take it yourself rather than killing an innocent person. But when that rationale is not present, that broad excuse rationale for the duress defense carries everything. So to flip to the mens rea point, the second main piece of Ms. Gafken's defense, I'd say that the prosecution in this briefing tries to walk a fine line here because what the lower courts did is they applied an objective standard. The trial court excluded the evidence that Ms. Gafken lacked the mens rea, the subjective mens rea, to commit the crime. She was prevented from proving that she did not have the knowledge that death or great bodily harm was a likely result. And so the lower court said this was an objective act-only inquiry, but on the jury instructions piece, the only way that this evidence is the same standard, the only way that the wanton and willful disregard language is the same as the knowledge that death or great bodily harm standard that the Michigan jury instructions provide is if it is also a subjective standard. So the prosecution kind of tries to take a third pass, but that third path doesn't work. This evidence of her mens rea is not duress evidence. It's simply an alternative route of admissibility. It's the same evidence that she wants to introduce. She just wants to introduce it for two different reasons at trial. So even if the duress route is unavailable for Ms. Gafken, she still should be able to introduce that same evidence to prove that she lacked the knowledge that death or great bodily harm is the likely result of her actions. And that subjective standard that the lower court rejected when it came to whether or not she could introduce this evidence at trial was inconsistent with the common law. The common law drew that line based on the defendant's subjective awareness of risk. And as with duress, this court has stated repeatedly that when it comes to defining murder, it continues to operate against the common law rule. And I think one of the more kind of pressing examples was Blackstone's example that we cite in our brief of a man who pushes stones onto a street in London, which even in the 18th century is an extraordinarily dangerous activity. But that same act could support, in his view, reflecting the law at the time, could either be murder or manslaughter, depending on the defendant's subjective awareness and their subjective intent when they were engaging in that act. If they intended to cause danger to other people, then it was murder, the common law analog to depraved heart murder today. Or if they acted without that intent, he said if they had cared other people, then that act was just manslaughter. And so the distinction was based on the defendant's state of mind. It was never based on the danger caused in that situation. So when the Court of Appeals drew this line based on the defendant's act only and said that the act was too dangerous to be involuntary manslaughter, and the trial court took the same tack, that cuts against the common law because the act is what it is, but it's the defendant's intent and knowledge of the dangerousness of the act that they're engaged in which drove the result. And this court in Dykehouse took that same approach and defined it as a subjective definition, and it's only the Aaron definition that cuts against it, but as the Aaron definition is best read as an alternative definition to say the exact same thing that Dykehouse is. And that requires a subjective awareness of risk. And nothing in Aaron intended that it was undergoing any sort of sea change to get away from this common law backdrop. And it was a felony murder case where they're defining it to clarify the malice mens rea that existed at common law. Malice was an ambiguous term, so it defined second-degree murder these three ways as an attempt to clarify that, which it would intend to incorporate that subjective standard. This court soon after in Dykehouse said that this is a subjective standard and defined it based on the knowledge that death or great bodily harm is a likely result. And it continues to this day. And there's no indication that it's ever an objective act. And in the case below here, Ms. Gafken wanted to introduce it in those 30 seconds. She never intended, she never understood, she never appreciated that she was likely to cause death to other people. She was panicking, and so she just drove really fast, and she was conscious but she never appreciated that risk. And that distinction is what distinguishes second-degree murder from involuntary manslaughter, and she should have been able to raise that for this purpose. So unless this court has any further questions, I'm going to reserve the remainder of my time.
You may reserve.
Thank you.
Thank you.
Good morning, Chief Justice, Justices. May it please the court, Melissa Keys appearing on behalf of the people. Just over 3 years ago, almost to the day, this court decided People versus Reichard, or held oral argument. This court answered the question of whether the defense of duress is available to a defendant charged with felony murder, where the defense is available to the underlying predicate felony. This court concluded that it could, and in so doing, this court corrected a clear inconsistency in the law. The appellant and this court, during their colloquy, recognized that the court was adopting a narrow rule extending duress to the underlying felony, and indeed made the point to appellant that the person could still proceed under a theory of second-degree murder. The trial court in this particular case properly excluded evidence that defendant was allegedly threatened because it did constitute a defense of duress. That was the law in 2018, and it continues to be the law today. The trial court also properly excluded evidence as articulated by the defendant because it was the equivalent of diminished capacity. Again, a defense not recognized in this state. Finally, while the trial court did not strictly adhere to the Michigan Model Criminal Justice or jury instruction, it is clear that this court has used different definitions of malice interchangeably. And more presently, this court used the same definition in People versus Reichard. The people believe that any errors that this court might find are harmless, and we respectfully request this court deny the defendant's application. I appreciate the opportunity to be here today, and I welcome any questions that the court might have.
No questions from me.
I'm looking at you.
I wrote Reichard, but that's...
I know, that's why I'm looking at you.
This court should not recognize duress as a defense to second-degree murder. The law certainly does not prioritize one life over another. It would be a radical change in the law, and as it relates to the particular facts of this case, the allegation is that Mr. Scandalito allegedly held what she believed to be a gun. She never identified it as a gun. She sensed it was a gun. She believed it was a gun and told her not to stop. What Mr. Scandalito didn't say is to travel at speeds in excess of 100 miles an hour. He did not threaten Ms. Gafken to drive at 117 miles an hour in a busy thoroughfare in Port Huron, Michigan.
Counsel, that might all be right, but doesn't that just go to whether the jury should believe her duress defense, not whether the jury should be able to consider her duress defense? Those seem like great arguments for you to make to the jury about her credibility, about whether she was acting under duress. Am I misunderstanding your argument?
I don't think the court is misunderstanding the argument, but I think that if this court is willing to extend the duress defense to second-degree murder, I think that provides a whole host or opens up a whole host of different issues as it relates to malice in general.
So is it extending it, or is it just being consistent with the common law? Do you have any example in the treatises or the common law or the restatements where something other than the choice between intentionally killing or being killed prevents a defendant from raising a duress defense?
Well, I think when you look at the ancient authorities, when you look at Blackstone and when you look at Hale, they did not distinguish between intentional murder versus non-intentional murder. They called it murder. I recognized that Lefebvre did mention or did talk about intentional killing, so I recognize that there is a disparity there as it relates to whether or not duress should apply to only intentional killings or not. But as it relates to the facts of this particular case, the fact of the matter is, it wasn't a situation where it was a kill or be killed in that moment. She made the conscious choice to drive in the way that she did. And I think that the speeds are relevant because not only does it show that she had a subjective appreciation of the risk that was involved because she was driving at some points in the turn lane when she was overtaking traffic, but when she also disregarded the red light. Yes.
Again, that all sounds like really good arguments to a jury about why her duress defense wouldn't be believable, and I'm asking sort of a different question, I think, which is, I don't know of any treatise or restatement that says that something other than the choice between intentionally killing or being killed is where a duress defense is prevented in a common law jurisdiction. Obviously, there are states that have passed statutes, and our legislature could certainly pass a statute that was consistent with the position I think your office is arguing.
We are, yes.
Yeah, but I'm just trying to understand if you're aware of any common law jurisdiction or treatise or restatement that supports that position.
I think that we laid out, not only in our own brief, but also an amicus brief, that there are common law jurisdictions that decline to adopt a duress defense to any types of murder. So we did go into that, and we briefed that particular position as well as amicus. But as it relates to, I understand that the court is interested, obviously, in considering whether or not duress should apply to this last form of malice. But under the facts of this case, we do not believe that it justifies the court taking that leap. And I understand that the court is asking whether or not it is an extension. But
yeah, I'm just trying to understand how what really we're talking about. You're calling it an extension, and I think Brother Counsel says it's the opposite of that. It's actually it's what the common law requires.
I think it's a recognition. I don't think common law. If we are relying on what the ancient authorities, I don't know if that's me or
I'm sure it's the sound system.
Okay. I think that if you look at what the ancient authorities have said, they did say that duress is not a defense to murder. So I appreciate that Lefebvre has distinguished that, but this court has never recognized duress as a defense to murder, and indeed in Reichardt pointed out that the parties could still proceed on a charge of second-degree murder because the duress defense was limited to, it was a narrow rule, it was limited to the underlying predicate felony.
Let me just give you the flip side of the coin of that question. Are you aware of any jurisdiction that has read the common law to permit the defense of duress to depraved heart murder?
Florida and California.
Okay. And why should we not?
Consider it here?
Yes.
I think that there are several different reasons, but number one, I don't think that the law should prioritize one life over another. I think in Reichardt, where the court clarified an inconsistency, a clear inconsistency in the law, I think that that's different than what would happen if duress now could be asserted regarding the third form of malice, depraved heart murder, and that is because when you're giving jury instructions and when you are instructing juries about what they can consider, oftentimes prosecutors, when they're proceeding under a second-degree murder charge, they're arguing all three states of mind, whether it be intent to kill or intent to cause great bodily harm or knowingly creating a very high risk that death or great bodily harm might result. I think that it would create some inconsistencies, and essentially, I think it would separate that third form of malice from the other two of second-degree murder. I think it would change the landscape as it relates to second-degree murder. I really do. This court is obviously the architects here and wiser minds than me, but clearly it would create some, I think, inconsistencies in how we proceed under a second-degree murder charge and how we instruct juries. I think that would be difficult.
Can you be more specific about what cases you're referring to, the Florida and California case?
I know you're not going to believe me, but I actually left my brief.
I believe you.
I swear, I had this big binder here and didn't bring my brief.
Happens.
Rookie mistake.
Justice Welch can't find her key in her car right now.
It's lost in my car right now, in the parking garage, so I understand.
In case you need a car.
Also, I want to touch on this, this link, because I thought it was important, when the trial court considered what the threats were, and he encouraged the trial counsel to provide some type of expert opinion or some kind of information that linked the alleged threat to the behavior that Ms. Gafken engaged in. And he did not, he could not, because it's difficult to explain where she starts at the stop sign of Bancroft and 24th Street. It's difficult to explain her behavior and her driving in between that point and the point of the crash, which was about 21 seconds. I appreciate the fact that there is this concern about depriving a defendant of their right to a certain defense, but as it relates to this particular case and her mens rea, I think there was evidence, either if you looked at it objectively or subjectively, that she created that or knowingly created a risk in willful and wanton disregard of the consequences that death or great bodily harm might result.
For what it's worth, I have your brief, or at least your supplemental brief, and your index of authority only has Michigan cases. So we'll ask opposing counsel about the Florida and California cases.
Thank you very much.
Thank you.
Thank you.
Thank you, Your Honor. So the authorities that have extended it to intentional murder, the Massachusetts Supreme Court has stated that it is an intentional murder only exclusion in Vasquez, 2012 Massachusetts Supreme Court case, and the Florida Supreme Court did the same thing in the case Henry. Both of those cited in our brief. And to the extent that they say that there was a case that authority that has extended it beyond intentional murder, extended that to resuscitation, I think the cases they're referring to are the California cases in the amicus brief. But those cases all arose on intentional murder cases. There was some language in the California case that said it's not applicable to murder, but they never arose on a depraved tort theory. They were all either first-degree murder cases or second-degree murder cases that proceeded on the intent to kill element.
So you're not aware of any jurisdiction that has extended it to braveheart murder?
I am not, Your Honor. And
I think
none of the cases in the opposing side brief seem to do it either. The one case that I would cite that found in preparation for oral argument was there's an Australian case that did come out in our direction. It was cited in it was in a law review article cited in the amicus brief. larger article from Dressler. There was a larger Australian case that extended it to intentional murder, or that extended it to that said it is not a defense, or it is a defense to depraved heart murder. That is the only authority we're aware of that has, beyond the Massachusetts and Florida cases that have come out in our direction, we are unaware of any cases that have come out in the other direction. And to the extent that we get into the kind of underlying facts of this case, I just say that today, your honors have heard a lot more facts about the underlying case than the jury did. The jury heard nothing about, from the moment the police went to pull her over, to the moment that the crash occurred. And everything that happened in the car, whether they believe it or not, is stuff that was all kept from the jury. If your honors don't have any further questions, we ask that you grant the application and reverse. Thank you.
Thank you. The case will be submitted.